August meeting of the Rappahannock County Board of Zoning Appeals, and everybody is present today, and Michelle Summers is here. So we've got, let's see, anyway, I've got it. We just had one special use permit on the agenda. And so the first item is to adopt the agenda. Is there a motion or any changes, modifications?
I'm going to have to ask for a change. After we adopt the agenda, we need to discuss the status of this board.
So do you want to insert that after?
That would be before the minutes or anything.
Before
The status of
The status of the board and the members on this board, because there's a question that has to be answered.
Okay, go ahead.
That's a motion.
Well, no, we can insert that in the agenda.
Well, I was just asking, what are we inserting?
I'm assuming he's talking about
Me too.
whether.
I was hoping to be specific.
I mean, I'm just guessing.
Yeah.
Okay, so the issue is there anything else that anyone wishes to add or delete? So I'm going to take that as a motion from Ron.
Yes.
To adopt it with the addition of discussing the status of our membership
Correct.
before the minutes. Is there a second to that?
You know, I might amend the motion to ascertain a legal opinion from our attorney, Mr. Lockhart.
That will well be part of the discussion because we're bringing him online.
As to the status of the board members. But,
Yeah. Well,
I'll second.
I'm certain anything can include legal opinion. So there's a second.
Yeah, I'll second.
Any other discussion? All in favor?
Aye.
Aye. Okay. Do you wish to, since it's your subject?
Okay, so that's, yes. Your status on the board, according to, or if you look at resignations and what have you, and how they're tendered, you're no longer a member of this board.
In your opinion?
In my opinion, and there's information that backs it up.
Okay.
I mean, number one, the county attorney, in his opinion, his conclusion is that you may not be a member of both the Board of Zoning Appeals and the Water and Sewer Authority simultaneously. I mean, you made your decision to resign this board and go with the
Is Mike able to hear this?
Here.
You can hear, okay.
You can hear us?
Okay.
So did you hear from the beginning? Okay.
Okay.
So we have our counsel, Mike Locke, who's from Salem. He's advised us on a number of things over the past few years, BZA related. Okay.
Okay, to continue. So that was the conclusion of the county attorney. Now, you had made your choice and you submitted a resignation from the Board of Zoning Appeals dated August 18th, 2021.
And I announced my intent to resign and my willingness to serve until I am replaced.
That
is my position. And that is the board, the members do serve until they are replaced when your term ends.
That is not true. The law states that if your term has expired, you can continue to serve until a replacement has been made. Says nothing about resignation.
That's not working, it's only a speaker and not
Oh.
a microphone,
Okay.
so it's
Is a resignation tenured the same as a resignation accepted and implemented?
Under current common law, from what I found today, It used to be that the resignation had to be accepted,
Right, that's what I
but
thought.
that has changed over the years, and now the drop dead date basically is the date of the resignation, or if you tender a resignation as of a particular date, then that is the date of your resignation. That was not done in Alex's letter. It's dated August 18th. According to, common law now, state law, the only reference I could find in state code as far as resignations goes is in the administrative end of the code. It's 13.1-859, which is resignation of directors. And yes, that does apply to corporations, but it's the only thing I could find. And it says a resignation is effective when the notice is delivered unless the notice specifies a later effective time.
Unless it specifies what?
It specifies a later effective time, and then you can resign as of a future date.
Which is when I'm replaced.
Well,
That is not, it can't be an open-ended.
What, he,
The code does not say that. There's a
isn't
date.
he saying that he's tendering his resignation
I'm-
upon being replaced?
You can't talk and he talks at the same time.
All right, let me ask this question. Isn't he saying that he's tendering his resignation upon being replaced? That's how I hear it.
You can't do that,
That's what I've done.
I quote. You may be what he intended, the things
That's
he
what
would
I
do,
heard.
but it is not. There's no code to back that up.
We do have a lawyer on the line.
Okay. If you want to,
Um,
and this probably kept us in by surprise, but.
well, no, we previewed this a little bit. But,
Well, Alex had mentioned it to me, and I said the same thing that I'm going to tell you, which is that this is a matter of conflicts of interest. That is a matter for the Commonwealth's attorney and the county attorney to address. Each of them has a legal authorization to issue opinions on that. I don't. And has anybody actually spoken to Mr. Goff about his opinion on this
Yes.
matter?
well, hold on.
Yes.
What I
Has
had
he issued anything in writing?
What I had done is wrote an email to the supervisors and Art indicating my intent to serve until I was replaced. I was pretty clear about that. And I asked if it was okay with Art. I think you saw that letter, right? And there was never any indication that it wasn't. You have a copy of that letter, correct?
Which one?
The one that you seem to quote from, the one that I wrote to the supervisors.
You wrote a letter.
Supervisors.
Wait a minute, you mean the one you just gave us?
No.
That's the one with the judge.
The board of supervisors.
We don't have a copy of that. Do you have a copy of that? No one, you didn't send it to anybody. That's part of this problem. You're not communicating with your board.
Well,
Normally when you resign, you send a letter to your board.
Well, I did.
indicating that you never got it.
I sent an email to everybody.
I never saw it.
Yeah, no, you got it.
Yeah.
It was to the whole board, yes. It was a different letter from the one I sent to the supervisors. But I did send an email to the whole board.
Okay, yes, you did. I know what you're talking about now, where you just in one line said that you intend to serve until replaced.
Yes,
So I'm saying is there's no legal basis for that. You can't make up your own rules when you resign from a public board. I'll read you from the bylaws of, and this is one of the ones I can find, but this is from Herndon, Virginia, or whatever. It says resignation. Any member who resigns from the BZA prior to the end of their term shall do so in writing to the chair, which you had to write over yourself, and you could have read a letter to the board. The effective date of such resignation shall be the date of the letter to the chair unless otherwise date is stated within the letter of resignation. And now that's there are rules, that's not case law or anything, but if you research the subject, you find that that's pretty much the case. Like I said, it used to be that the resignation had to be accepted by the appointing authority, and that has over time sort of gone by the wayside. But in this case, I just talked to the clerk of the circuit clerk, Peggy, And she stated that she had gotten a letter from, she had gotten communication with the court, and there is a advertisement in this week's paper for a replacement, which indicates that the court has accepted your resignation.
Yeah, but whether or not the court has accepted that resignation, the letter that was accepted by the Board of Supervisors and apparently.
Board of Supervisors didn't have anything to do with this.
Yeah, but Art Goff does,
Art
and
Goff,
he was
sure.
CC'd on it,
Yeah.
and if the date that Alex put was when I am,
It's not a date.
it's a date,
Right,
it's a
okay.
time, it's a marker
time
of
certain.
time. The
I'm sorry.
date, the time at which I am replaced. I mean, it's perfectly reasonable to see that.
But the code doesn't allow that. The
Yes,
code
but
only
you read
allows.
it does,
Well,
you
that's
just
your
read it
reading
does,
of it.
excuse me, you read it does, the last sentence of what you said, unless otherwise in the letter. And it was otherwise in the letter. I don't see what we're arguing about.
Well, Mike, do you have any thoughts?
My advice to you is, without having gotten a definite opinion as far as what Mr. Goff is going to enforce as the Commonwealth's attorney, knowing that the judge is taking action to replace Mr. Sharp, so clearly, if the judge is aware of the issue and taking expeditious action to fix it, I'm not in a position to make an adjudication to the entire BZA of whether Mr. Sharp or Mr. McGill is correct. You've got a couple of options. If you want to defer everything for a month and make sure and send a letter to the judge telling him to move it along, that's one option. If you want to vote to ask Mr. Sharp to sit in the audience for the night, that's another option. If you want to vote to allow Mr. Sharp to continue, that's another option. I can defend any one of those three options, and it's up to three of you members of the board to make a decision on what you want the answer to be.
Okay,
And just to add that the opinion came from the county attorney, not the Commonwealth's attorney. And of course, our occupies both seats, but if we just came from, no, it's important to Art. Art sits in two different chairs,
County attorney's letterhead,
but,
you came on this county attorney's letterhead.
Correct.
well, he doesn't even have letterhead, he
Well-
just put county attorney by his name. But anyhow, yes, it's under the county attorney. When I talked to him, he said, he really wouldn't give me an opinion. He said, I was asked to render an opinion on whether Alex could serve on both boards, and that's all I've been asked to do by the county administrator. So I can't say anything other than that. And that was basically his statement.
Okay.
we do have also another matter we're gonna ask you about after this, but, well, so would the issue be, it sounds like one of the options is I can be permitted to continue
Yeah, I'll make
until
that,
I'm replaced.
I'll make that motion. I move that Alex be permitted to continue as chair of the BZA until there is a replacement.
I'll second that.
Okay, is there any further discussion?
Yes. I'm also, because one of the reasons I'm raising the question is that if in fact you are, because basically right now, sitting here, you're in violation of the code, state code of Virginia because you
Well,
are
that's your
Well,
interpretation.
the lawyer gave us that one option.
Let me finish what I'm saying. You are sitting here, and by sitting here with what Art Bob told you is that you're in violation of the state code. You're serving on two boards simultaneously, and if you're on the Board of Zoning Appeals, you can't do that. So right now, you're in violation of the state code,
In your opinion.
in my opinion.
Right.
Now, because you are in violation, and actually I still think also that your resignation was on the 18th, if you vote on anything, that vote is meaningless.
according to you.
Right.
Correct.
Okay. Is there any other discussion?
It's a question that needs to be answered.
I would just
I'd like to
add,
make a comment. Oh, go ahead.
well, I'll just make one quick comment. Perhaps there may be a risk, I don't know what the risk is, but if we do move forward with a decision on something, and it is later found to be an issue, then that could be a reason grounds for appeal or other such issues. Is that correct, Mike?
It absolutely is, yeah. If it's the 3-2 vote, that could be an issue.
Agreed.
And that is certainly something to take into account as you make your decision.
And of course, that is something that would have to be appealed within a certain period of time.
Sure, that would be appealed within 30 days.
30 days.
Yep.
Okay.
And I'll ask one more question then. And this is past history of resignations from the board. I was appointed to replace someone who had resigned. The board, at that point in time, had 4 members, and there was no problem. The board was able to still do their job, so why do you insist on remaining on the board in violation of the state code?
In your opinion?
Well, I think the only way this is gonna get resolved is through an official opinion. I mean, I don't know if we wanna take the vote or if you would entertain just sitting out for this one.
For
But
this one?
just to keep it
case?
safe.
Well, I want to make a comment. I think that the question was settled in the last line of what you said, or in terms of the resignation, unless it is stated otherwise in the letter. And I think it's very clear that it's stated otherwise in the letter. And I can't see how that point can be argued.
My intent is to serve until I'm replaced.
Right, and that was, you read the code, and that is allowed by the last.
No, it's not.
And
Well, read that line again.
one thing that I would just say is I was appointed to this board in 1990. I was appointed to the sewer authority in 1998, thereabouts. And this issue has come up a couple of times. There have been 2 that I know of, written opinions tendered by Peter Luke that found that there was not a conflict. So does that mean that every vote I've taken over the last 22 years has been illegal or somehow wrong?
It could be.
Oh, well. Okay.
Well, I wasn't here when
It was never appealed, but, you know,
Well, I mean,
technically, yes, it could be.
so,
May I make a point? The criteria by which we live or die in terms of whether our decisions are deemed to be actionable or not, I believe, is whether the issue is debatable. And I think we've pretty much shown that it is.
you mean that the action wasn't arbitrary?
Right, or I mean, that we can say, okay, you know, there's things on one side of this question, there's things on the other side of the question, it's debatable. So we are quasi-judicial body, we can make a decision based upon, like, whether we could simply vote. I would be, I mentioned this last meeting, I would be reticent to vote without a preponderance of the votes in favor of it. Or I think we could vote to just suspend the rule and
Which rule? This rule?
the rule that allows you to not be
Well,
there.
I don't know if we can necessarily do that. No, I mean, that's an interesting idea.
But I mean, don't we have the choice of, I mean, if it's one way or the other, we get to choose.
What's that?
The rules of Perkin are not the rules of Rappahannock, but
Oh, okay.
is it McNeil or Macula?
Macula. Macula.
Macula. You know, as he says, the common law is not 100% clear.
Right.
And that's why I've been advising you, and there's some advisory stuff out there. That's why I've been advising you that the legislative body has the authority to determine has generally a common law the authority to determine the qualifications of its members.
All right.
Okay. And so,
Unlike the circuit court clerk, for instance, you take your oath of office, but generally speaking, it's up to you to decide whether, unless Mr. Sharp makes it on his own, it's it's up to you guys to decide whether he gets to stay in his chair or not. And as far as it goes, certainly the safer thing is hope that all the votes are at least 4-1 or 5-up.
Well, the other thing I could offer to
That's
do,
where you
I'd happily offer right now, Ron, you chair this meeting. And I'll sort of defer a little bit. And maybe I won't make such a big impact. And maybe we can get through this meeting. I mean, that may be the best you can hope for.
With the action of requesting an official
No, I mean,
opinion before
well,
the next BZA.
See, I sent also Art's opinion to the judge. Now, I have also talked to a couple people about becoming members, and I do have one probably very qualified person who has already submitted a letter, who I think would probably be quite good. But again, they're advertising, so I'm not looking to make this a lifetime job. I'm just saying that I think it's reasonable to do as I suggested, which I would stay until I am replaced. And I think the court apparently is advertising, but that's what they've been doing, is advertising. As soon as they know the
You
position.
made that offer, and nobody's spoken, turned it down, the court is not.
Yeah, and I've made Art aware of it, I've made I know the supervisors, it's not their deal, but I've made the supervisors aware of it, Art aware of it. Mainly that was in the context of the other board. And then I have made the chief judge, whatever you call him. Is he a chief judge?
Yeah.
Yes, the chief judge and the clerk of the court in writing, and I put this issue before them. And so I would expect that if there was any problem with me serving until I was replaced, that I would have heard something. Peggy calls me from time to time, has no trouble getting a hold of me. So, you know, I would say absent that, or a call from Art Goff, or an email, or something. And Art's had several weeks of notice about this. So,
Art,
well, I'm just saying.
I was going to say, but he indicated he had no say in that end of.
Well, so he's
What has
not
happened?
rendering an opinion. But
Right.
he might be the one who, if he had an opinion, would certainly be expected to render it.
Well,
And he has no opinion.
he did that already. It's in the last sentence of
But
his,
we did
opinion.
not discuss the method of my, ending my service. And I still feel like if you've been doing something for 22 years and an opinion is rendered, right or wrong, there have been conflicting opinions, I accept his opinion. And I'm not challenging his opinion. I'm just leaving in my own way.
Ms. Ritter, would you entertain modifying your motion to, which I believe was to continue with Alex as chair for the meeting, but with the request for abstaining for the special use permit, just to be on the safe side there.
Sure.
I think that is really the only risk.
So
But as far as the
yeah.
major chairing the rest of the meeting, I see no issue
So
with that.
would you be saying I would refrain from discussion during this and directing that part? So let Ron chair that part? Or am I allowed to render opinions?
Mike,
Just not vote?
can he be involved with the hearing, or does he need to abstain? Can he abstain from only the decision, or does he need to abstain completely, almost like?
Well,
It's
I
a
could,
it's a question of abstaining or recusing, and there's a differentiation there, in that if you
well, I could abstain, okay. It sounds
abstaining in advance is sort of recusing yourself.
Ron,
Well, I
I'm not abstaining in advance, we're discussing it. What I'm suggesting is that Ron could chair that part of the meeting. And that I could, by vote, if it's agreeable, then I will be involved in the discussion, and I just would decide at the time, am I going to abstain from vote? And I would make that decision at the time, which I predict I probably will. But, Because one of the options is me fully participating all the way through. That is an option, but I'm saying I yield to the safety.
Another option would be is if you decided to sit it out there, that you could make your comments during the time. You become a public citizen when you cross that bar, and I think you would be welcoming the comments and discussion to
But-
make your points clear.
But that's sort of saying that I have some conflict with land use application, which I really don't.
You don't, no. Well, I didn't try to say that.
No, but I'm just saying
That's it, okay.
that I don't. I mean, this may be something we should just make a decision on and go move on. So
Yeah,
are you
so,
going to amend?
Diane, do you want to restate the,
I'll reiterate what I think your motion is with the modification. So as a board, we are deciding to move forward with Alex as the chairman for the meeting, with the exception of the public hearing in which he will be abstaining from the discussion and vote.
So I'll,
okay,
Turn the-
recusing himself from,
but can I still sit here? I mean,
yeah, you can recuse.
And the way that we've discussed recusals before, you physically and orally remove yourself from the conversation. That's what we had stated before.
so I should go to that part of the thing.
And then you would list it as, he will recuse himself from the deliberation, not.
Which would you like,
Is that, I mean, I'm modifying your motion.
well, let's say abstain then.
Abstain.
Would I be allowed to be involved in just the very first part, which is discussion of that rule about, yes, I think I would.
Yeah, because you're sharing the meeting.
Okay. So once we hit this application, I'll go sit in the crowd.
So he will be abstaining from the public hearing.
And that-
Is that correct way to say it,
Motion on
Mike?
the floor right there.
Yeah, I think it is. Motion,
They recusing himself from the public hearing if he's stepping down from the dais, but
Yeah.
otherwise would be abstaining.
Okay.
abstaining from that particular. But I think that's really the only thing we'll have. So there's a motion and a second. At the risk of
There is.
there is
I'll
no
second it.
anything else. All in favor?
Aye.
Aye. And so I do. Oh, no. I do have a question about, so if I were to inquire with the judge between now and then, and I will just see if they accept me being in position until I'm replaced, that is a matter for the court to decide. So I will see if I can just put that position. Hopefully they'll have a member. But as you'll probably see, it's a little, the dynamics are a little different when you just have 4, because then you can easily, and a lot of times you have these 2 versus 2 situations that, you know, that 5th one does make a difference regardless of which position. Okay.
Well, wait a minute, Mike, would it be your advice then to get an opinion from Art or to see if the judge will render an opinion? About Alex's
The
stuff.
judge is already advertising for potential candidates. By 30 days from now, this will probably be a moot point.
Yeah.
Right.
But if Alex believes that there is a possibility of there being a conflict of interest act issue here, he, as a public official, can ask the Commonwealth's attorney for an opinion as to a conflict of interest issue.
Relating to just serving until I'm replaced.
Well, it wouldn't necessarily be on the issue of whether it's served until he's replaced. I think that you can write in a resignation letter, I will serve until the occurrence of an event that is likely to occur. I know that has certainly happened many times in my experience, and I've never heard anybody argue about it, but and so I can't say for sure that it's right, but I also have seen it done enough without objection. I don't know that, I'm not comfortable saying it's wrong.
Okay.
On the other hand, it certainly situation where you potentially have an irreconcilable conflict. This is, and in that instance, probably the Commonwealth's attorney would be in a position to render you an opinion.
Okay.
I'm not going to say that Art will certainly say yes or no, because Art is a smart man who can make up his own mind, but that would be where I would turn if I was a public official involved.
Okay, good advice. Okay, well, we've already resolved that issue, correct? With a vote. We all voted.
I believe so. I don't know if I need to add a motion, but should I add a motion to request formal direction from the Commonwealth Attorney as the board as well?
Well, how about if I'm going to participate further, maybe I should bring some sort of,
He could be replaced before the next meeting, which,
They may not have applications.
well, it had,
Although you said that
the last time it took about 8 months to
Yeah.
replace.
Since they
I
lost
mean,
the
that is-
application.
Well, they lost
I
it.
just don't, I don't want to ask an opinion of the Commonwealth Attorney without the direction of the board. So I'll make a motion to have the board direct.
Well, did he indicate that I should ask?
He
if
said
I-
that you should ask as a conflict of interest from yours, but will that cover the issue, or should we ask as the BZA as well?
Well, if there's a,
You can't really ask the Commonwealth attorney for anything.
Okay.
It's actually a public official, him or herself, who has the ability
Okay,
to
so I
ask.
will-
So you will ask.
and then
Okay.
if I attempt to come to the next meeting without some sort of answer, then I guess that would be a different story, right? I mean, is that fair?
That's good.
Do we don't need a rule of motion on
No,
that? Okay.
motion withdrawn.
Okay, then the next question, which I'm going to participate to the extent of how it relates to our procedures, but Mike, as you had rendered this opinion, which was informative, yeah, I made copies. And so basically, if I understand this correctly, the special use permit, there isn't any requirement in the state code that a applicant be represented by an attorney for an entity. But you do also say that if it's in your rules and regulations, they should either be followed or in a discussion with you today, or waived in some, officially waived for that.
Well,
Changed.
Well,
Waiving and
you
changing.
need to follow your own rules. If you want to change your rules, you should vote to change the rules. There are times when you suspend rules, which you may do by unanimous vote. You may suspend a rule. If it's procedural, it prejudices no one's rights. So those are both, again, I'm giving you legal advice, which three of you need to implement how you like, but that's my legal advice. I think that you saw it, and I certainly have no problem with saying that there's not an automatic problem with requiring a person to represent themselves by an attorney before you, or I'd say a person, a corporate entity. I will say that with regard to SUPs, that is a legislative action. People have a First Amendment right to approach and lobby you with respect to legislative actions. So even if they have to appear by an attorney before you, they have a First Amendment right to send you a letter or make a phone call to you. Now, you don't have to read it, you don't have to pick up the phone, but they have a right to approach you. It's a part of the freedom of speech and the freedom to petition your government official. As to when you're doing a quasi-adjudicative or quasi-judicial decision, those by default would be by an attorney, just as a matter of unauthorized practice of law principles. However, the unauthorized practice of law principles in Virginia do allow administrative bodies that make quasi-judicial decisions, which is to say, someone like you, to make exceptions to that. You could allow people to represent themselves. You could just say, in all cases, you could instead say that can appear by a member. You could say LLCs can appear by a member, something along those lines. You just need to have some type of reasonable rule. And in fact, small claims courts make those exceptions. Closely held corporations and some other types of corporate entities can appear in small claims court by a corporate officer. It's an exception to the unauthorized practice of law rules. Now, if you're a big, stockholder-owned corporation, hire yourself an attorney. But it tries to cover for people who are basically small business owners, and it doesn't make sense for them to flip an attorney $5,000 to plead a case that is only worth $2,000 to them. So the courts, the General Assembly can recognize that. And you also, as an administrative body, have the authority to recognize that if you want to do so. But there's no requirement to do so. Certainly, in my experience, going around the state, it is not unusual for there to be a requirement for attorneys on quasi-judicial, but that there usually isn't on an SUP. The reason why is, frankly, being expeditious about it. With a quasi-judicial decision, you are almost always making a decision that is really, there's a lot of facts to find, but there's a lot of legal issues that need to be decided, and it makes sense for people to have lawyers who can present those issues in clear terms. On the other hand, with SUPs, that is a legislative decision. It's not a yes, no, check down the list type decision. It's a balancing of factors and isn't fairly debatable. And oftentimes, again, just as a matter of experience, a professional planner or development consultant or engineer is oftentimes far better at explaining what's going on in the application and why it's a good or a bad idea, or even a smart citizen, than a lot of lawyers are. So you're almost doing yourself a service in terms of the explanation that you might get by saying, why don't you have your surveyor come in and tell me about the plan you've got, rather than why don't you have your lawyer come and try to get an understanding from the surveyor. So that's my 2 cents at the end, which you're free to ignore, but as to the other part, that's my opinion on what the law is, which again, free of you could ignore it if you want to, but I'm fairly confident of it.
Okay, so we would have, if we wanted to remove this requirement for special use permits, we could do one of two things. We could unanimously make that revision to our procedure right now.
No,
Yes.
we can't, according to our rules, we can't.
Yeah, if you are planning to make a change to the bylaws, my recollection, and I don't have them open on my desktop right this second, but my recollection is that if we're going to make a change to the bylaws, that needs to be, everybody needs to be given 1 meeting's notice. So you couldn't make that change until next meeting.
Okay, so the second thing would be to suspend that requirement for right now.
Which you could do by a unanimous vote.
Okay. Well, that should we suspend that requirement?
I move we suspend that. Well, we have a motion.
Well, let's wait a minute, are we done?
We have a
You probably need to go over
motion.
there.
He is.
Oh, yes, Paul. That's in the bedroom.
The problem that I see with this suspending the requirement is that on 2 occasions, we've asked the applicant to appear with an attorney.
I think those were variances.
No,
No, that's
this
very-
particular.
Oh, in this case.
Yeah,
Well, that's, well, but, yeah, I don't think that really is what we should be doing. I mean, I
well,
think,
but that's what we did.
We have to follow our rules. The rules said,
But he's saying we could suspend that, and I'm just saying,
do that,
in
yes.
fairness to someone who's come.
No, but the fairness is this, that both times, when she's appeared, we said, please bring an attorney. And then the next time she doesn't come with an attorney. And then last time, please bring an attorney. Who
Okay,
doesn't
well,
come with an
I wasn't-
attorney? You know that, I mean, I just think we need to hang in with them. I mean, we may want to change this regulation, but I just don't see how you can keep telling somebody to do something and then they don't do it, and you say, oh, okay, you don't wanna do it, we'll just suspend that rule.
I wholeheartedly agree. The board voted twice to bring legal representation, and you don't have legal representation coming, or you're again without legal representation. That's problematic.
Yeah, that is a good point.
Well, then maybe I can stay in my
Unless you want to consider our advisor here.
What?
Unless you want to consider this legal advice.
Well, he has said we can suspend it. I think the policy, and again, probably doesn't matter for me what I think, but going forward, you should not require special use applicants to have an
I
attorney.
totally agree with
Nobody does. Nobody does.
I totally agree with
For a special exception or special use permit. So, I mean, sometimes you have one applicant who's caught in the never land of between what should be and what is.
Yeah, but,
And I mean, I hear your points. I think what I had put on the agenda for the last meeting, which I was not here, but was to hear that about that requirement. And we did not have this opinion in hand at the time. Now we do have this opinion in hand, so. Which indicates that, you know, in my reading of it, we can and likely should change the rule so that.
I'm all for that, and I think we should do it pursuant to the bylaws.
So where does that leave when the application, there is a 90 days, what was the 90 days that had to be resolved? And that comes one day before the next meeting. So I mean, in fairness to the applicant, maybe have her bring an attorney to the next meeting and have the meeting a day or two earlier. I mean, you know, because you do have this case where you've had it bumped along for what I think is.
Yeah, but we bumped it along not because of us, but because we're following the rules of procedure. I mean, I'm happy to do, to
Yeah,
have the hearing
okay.
early, but I just
Well, I
don't
mean,
think you can lay the blame for the board.
And keep in mind that the 90-day rule can be extended at the request of the applicant. If the applicant is fine with extending it, it can be extended.
Since we do have an attorney here, I am curious. If you have a special use permit in front of a BZA, you've directed the applicant to do something several times, the applicant comes back for the third time and hasn't done that, you know, what is the board to do? Do we just keep asking for the same thing until it occurs, or what?
And then
If they
drop.
haven't complied with your bylaws, then you need to, you have several options, but the most obvious is to, you know, turn down the SUP. Now, they might very well then get an attorney and appeal you to circuit court, and that won't work as well. I did want to note, just to add a bit of information to this, the 90-day period is what we call directory, not mandatory, which means that there's not a penalty if you go over 90 days, so not as though you lose jurisdiction of the application. And there was a case about this, that's why I can say for certain. However, after 90 days, the person can probably get a writ of mandamus to order you to make a decision at your next regular meeting. So the fact of the matter is that if you did want to punt this to the next meeting, there's almost no way that you're actually going to face a problem in terms of it, but you certainly don't want to make a habit of it, because sooner or later somebody will get a writ of mandamus if you get cavalier.
Well, there is another aspect to this. The Moselle, those were 3 LLCs. They were all presented by the members, not a lawyer.
Mhm.
And we accepted that fine.
One was an LLC, the remaining was.
Well, but still, but in other words, still, we allowed an LLC, and we have, you know, routinely allowed an LLC. Now, maybe we weren't looking at this rule of procedure, but we have done that multiple
The
times.
point is, we've asked the applicant
Okay, I got you. I got
twice
you.
in 2 different meetings for legal representation. And this is the 3rd time, I'm
Okay.
sorry, but they come
Okay,
without
okay.
representation.
Okay, well, anyway, that's just, but I do think as a general rule, the board should not require that.
Yeah, which requires changing the bylaws. which we
Or
can-
suspend.
If we change the bylaws tonight.
We
then-
cannot.
Apparently you have to have a meeting.
They cannot.
You have to have a special meeting to do that.
It's not a special meeting, you just have to discuss it at a meeting, and then you vote
Set
on
it-
it. at the next
set it.
Right, that's what I was like.
So we can decide at the
Yeah,
next
I
meeting.
thought that was the case. So we can put it on the agenda for the next meeting is what you're
And then
saying.
if she came to that meeting without an attorney,
Well,
we'll see how it
Well,
goes.
if it worked out that we decide to not suspend the rule, then she'd be in trouble, wouldn't she?
Okay, so if I'm understanding the parameters, the 90 days isn't really something hard and fast that terminates her application.
Right.
So it could be just held at the next meeting. And you could do is what I was hoping would have been done last month, is to address that. It turns out it wouldn't have happened anyway, but to address that question, so maybe the board would consider tonight setting that question for the next meeting, which would be whether to remove the reference to the special use permit from the requirements for an attorney representing a legal entity.
Yeah, I think we should do that, yeah.
And I don't even know if that will necessarily happen in one meeting. It might, but it could be something we discuss over a couple meetings.
It's a pretty
Well,
straightforward
There's
question.
no time like the present to get started.
Right, well, we can discuss it, I just don't think we can make any changes.
Now, but you could in the next meeting.
Actually, I believe we could, even though it didn't end up on the agenda, agree to, first we have to take care of what we're going to do with the permit that's before us. After we're done with that, I don't think there's anything that prevents us from discussing what change we would like to make in that, and then we could vote on that at the next meeting. That would meet the requirement. There just has to be a meeting, or time between the discussion and the vote.
So Mike, is it true that basically, if I'm understanding it, you have to decide at one meeting to present that at the next meeting? Is that, to discuss it and act on it at the next meeting?
Probably set down the wording.
Yeah, procedurally speaking, you need to have a motion made to make a decision, a motion made and a vote made to have a decision made at the next meeting. It's the idea is that nobody will make a rash and quick decision on a rules change just to suit one particular application. The idea is to give everybody the chance to think about it for a month and be sure that what they're doing is really a good idea to grant seats back.
Just remove the word special.
Yeah.
I think it would be a very simple edit, really. Well, I don't know if I mean, since it's not on the agenda anyway, we could agree upon the wording. You have that in front of you?
We could agree upon the wording tonight and vote on this next meeting.
And have that, and it could be put on the agenda for the next time with that wording, or that motion. But,
Okay, so what we would, the motion would be if, we would like to
So we're going to
amend.
discuss that now, or
We are.
We're sort of off the agenda.
we are discussing that right now.
It's only, the motion is only to get it to a discussion for next
Yeah.
meeting.
No, but what I'm saying is that we have
Oh, right.
an item on the agenda that we should be
Well,
dealing
one
with
thing,
first.
you're gonna get me to go into the crowd when we're finished this little bit, so it'll just take a second. You wanted to, it would be just striking that, reference to the special use permit.
I I think the way you want to do it, if the applicant or appellant is a legal entity, corporation, limited liability company, partnership, trust, etc., must be represented by counsel before the board.
In a, well, first of all, you might even want to modify that, but
Yeah,
for a variance or special use, what is the other one, an appeal,
for variance or appeal.
for variances or appeal. Okay, so all you would have to do would be, you could say, if the applicant or appellant is a legal entity, corporation, limited liability company, partnership, trust, etc., making an application for a variance or an appeal, it must be represented by counsel.
I would say, I would add or other quasi-judicial decision, because you could wind up with other situations. You could wind up with vested rights, you could wind up with other weird situations that you have not foreseen, and you will wind up calling me and I will wind up scratching my head.
So, or other, for variance, appeals, or other quasi-judicial matters, I guess. And that will be set for the next meeting.
Okay, so I'm making a motion that we discuss that at the next meeting.
So the motion is to make that
To make this
add
wording
this
here.
wording. Is there a second?
I'll second that.
Is there any other discussion? Ron, are you seeming okay with this?
Yeah.
Okay, all in favor?
Aye.
Okay. So with that, I'll save my 20-minute speech for the end. No, I'm kidding. So I'm going to sit down and turn it over to you. Ron.
Okay. So you are recusing yourself now? And why you are doing this?
Mike, I think we're good.
I thought we discussed
Yeah, I
it.
think we're,
We're good?
We're good. Thank you, Mike.
I know three of you are new. Good to see you, Ron. Good to see you, Alex.
Good to see you. Thank you very much.
Thank you, Mike.
thank you.
Okay.
Okay, I did not get an answer.
Sit on this side.
Alex, are you recusing yourself?
I don't know.
The motion was abstained.
I'm not participating in the discussion, the managing of the meeting, or the vote of this. I don't know what you want to call it.
Yeah. Okay. Put in the minutes then that the chairman didn't feel like participating.
The
I don't
chairman,
know.
I'll just say the chairman has recused himself.
Thank you. Okay. Next order of business is the Sonic Burger.
Hold up, Mr. Chairman, did we do the minutes from July?
Oh, that's right. Let's do the minutes. Does anyone have any comments on the minutes?
I think they were good.
They were short and sweet.
Yep. And to the point. I moved that the minutes from July 28, 2021 be accepted.
Here a second?
Adopted.
Here a second? All in favor?
Aye.
Okay, now moving on to the public hearing. We have to decide where we're at. And we have a request that hasn't been met, which was basically controlling when or if we open the public hearing. So we have to decide, we can, quite honestly, we can open the public hearing, but under our present rules, I guess, I mean, and what Mike said sort of comes into play is that the applicant, under First Amendment rights, does have the right to make comments. Although the comments in that situation, and that has happened when we have attorneys here, is that, their comments have to be tempered so that they aren't crossing the line into judicial preferences or whatever. So basically, just a fact, a presentation of facts, I think would be acceptable at that point, and then we can also hear from the public. Is that?
Well, we can suspend the rule only because we know that we have this change coming. We've already wordsmithed exactly what it's going to be.
Right.
It will take effect at the next
All it
meeting.
takes is unanimity.
It's not in conflict with the Code of Virginia or the zoning ordinance. I think it's fair, especially considering we already have the language that we're going to modify. But we do have to have all of us have to vote.
It's gotta be unanimous.
Correct.
Yeah, does that count?
We suspend the rules.
No.
What?
Does that count, me? To make it unanimous?
Well, wait a minute. I was saying, you recused, and because it's pertaining to the reason you're not sitting at the table, no, you can't, you can't vote on it.
I'll make the motion to suspend the rule for Article 6, Section 6, where am I? 6-2, only because we are looking to modify this rule at the next meeting.
Do I hear a second?
I'll second.
Motion's been made and seconded. All in favor? Okay, unanimously it's passed. Therefore, I'm now going to open the public hearing on SUP 21-03-01, Burgers Sawmill LLC, custom sawmill on tax map number 18-49A. And we have the applicant present us with her information.
Would it be acceptable if I just sit here and speak to you?
That'll work.
And I have handouts, if that would be objective to you. So just a bit of background. In 1950, my father bought our property from Old Man John Kaiser. It's always been family owned, and the members of the LLC into which this parcel was put in the early 2000s are my 4 children and me. We've always operated as a working tree farm. We've been in the land use program since the county implemented it in 1982. We have a forestry plan with which we comply, as well as all other stipulations of land use and the Rappahannock County zoning ordinance. We've been good neighbors, respectful and responsible. Going back to the 70s, the family has assisted with adjacent water and property access through handshake agreements and outright gifting of a parcel so that the preferred house building site could be used. We've allowed our neighbors to come onto our property to get to parts of their land so that they could log. We've always allowed hikers and horseback riders national park access across our property, and we've let friends and neighbors hunt for free as well. Located in Harris Hollow, on both sides of us, there already exists sizable agricultural and limited commercial uses, including farming operations and construction trade and heavy machinery support businesses, with the accompanying traffic of the enterprises themselves, as well as employees, suppliers, and customers. Their business is varied, primarily cows, and ours is trees. The 166 acre parcel we're discussing is zoned agricultural and conservation, which is the ideal location for the ideal complementary use of this custom sawmill SUP. And then with regards to the packets that I just gave you, just what I'm going to point out going forward will reference points in there. So what are the standards for granting a custom sawmill SUP? Section 170-A8 of the Rappahannock County zoning ordinance defines a custom sawmill with a single sentence: a mill in which most of the product is sawed for retail sales and does not employ more than 5 persons in the on-site operations. We agreed to all the conditions initially proposed by Ms. Summers at the May 19 meeting of the Planning Commission. The recommended conditions placed on this SUP by the Planning Commission were, in our opinion, arbitrary and unreasonable, and amounted to a solution in search of a problem. So the first one, the first condition that they put on it was recommending placing a 2-year term limitation. To allow the startup of a business, including capital outlay, with the specter of being shut down in 2 years, irrespective of compliance, is unreasonable. If there are complaints of zoning violations, there's a procedure by which the permit could be revoked. We request that any review this board may impose be in 3 to 5 years, if at all, because it is unwarranted in this case, and to waive the reapplication requirement, and therefore no further limitations on duration. I'm sorry, and thereafter, no further limitations on duration. The hours of operation have been stated as Monday through Friday, 10 a.m. to 4 p.m. Those hours would effectively mandate the 5 or less employees provided for in the custom sawmill definition all be part-time, working 30 hours a week, which is unreasonable. The sawmill would also be used for our own farm purposes. Is that also limited to 10 to 4, no weekends? Chainsaws and tractors are not limited in that way. How will that be differentiated and enforced? And there are no hours of operation in ag zoning. We accept the initial staff recommendation of 7 a.m. to 7 p.m. as per ag zoning. A condition of no sublease has been recommended. If this condition is meant to mean sublease of the property, it's not in the county's authority to dictate to landowners sale or lease of property. If this condition is in regards to contracting the sawmill operation out to a third party, the LLC as property owner is still subject to the zoning ordinances, not the contractor. Therefore, the need for the condition is unnecessary. No commercial signage. We are subject to and will comply with the county sign ordinance, making this condition unreasonable as excessive. No retail sales from the site is number 5 condition by the Planning Commission. It's contrary to the custom sawmill definition wording of the product is sawed for retail sales. If the defined retail sales are not to occur at the property, then where? Section 170-68-8A1, which I'll discuss more in a minute, addresses retail sales and daily trips in association with that use. And then last recommendation from the Planning Commission is 4 trips, 2 round trips per day, 2 axle trucks for logs in or lumber out. We question the basis and standards for this restriction. The type of equipment used is irrelevant to the proposed use. VDOT has no issues, and we have already agreed not to use truck-trailer combinations in excess of 26,000 gross vehicle weight. Moving to the section 17053, which I just cited, which is a site that's just the general standards, the framework for the zoning. Subtopic A, or subtopic 1 is hours of operation, and that's been addressed. Access to the subject property, it's been put before VDOT, and they have no issues. Number 3 is protection of surface water and groundwater. There is access to the property, and it's through a ford. We've been driving through that ford for 71 years, and we've never had any issues. Lighting is not an issue. Adequate sewer and water supplies are not an issue. Sound limitations as needed to ensure peaceful enjoyment of the neighboring properties. The siting of the mill will be no closer than approximately a quarter mile to any residence. There's already noise from surrounding agricultural uses, and the sheets that I've given you, there's a couple of pages about OSHA decibel ratings and what standards is acceptable to be exposed to for 8 hours a day. And that is, the 90 decibel rating is when standing next to the operating equipment, per the portable sawmill manufacturer's tech sheet, which is in that packet. 7 under that section is structures. That's not applicable. Homeowners association, not applicable. Development, not applicable. Provision of utilities, not applicable. Control of smoke, dust, and odors. The staff recommendations referred to Title 10.1 of the Virginia Code, and those issues are not applicable. The sawmill engine is highly efficient, and it will only be producing sawdust. And the last issue is bonding, which is not applicable. Referring to section 17068, which I mentioned earlier, under, and it actually is it's category 7. So these are specific standards applicable to ag. A starts with all uses with retail sales, and it goes on to say something about year-round or what have you. But it designates access, and it says that if you don't have a paved secondary street, then the access should be limited to an average not to exceed 10 vehicles a day. Well, we do have a paved secondary street, but we would be amenable to agreeing to the limit of 10 vehicles per day. And the clear intent here is to permit on-site retail sales. Section 2 under that category is no detrimental use to the continuation of any adjacent agriculture, horticulture, or forestry operations. And I think that does not apply to us. We are not going to be causing any kind of detrimental use. And then the third refers to health department permits and conditions. Mitch Carter declined to weigh in on this. So in conclusion, as county residents, we duly and in good faith applied for this least impactful sawmill SUP, custom, not commercial, for a type of enterprise fully compatible with Principle 7 of the RIP Comprehensive Plan, as cited in the Zoning Administrator Staff Report. The Board of Zoning Appeals will be encouraging a business that cannot be any more integral to the history, identity, and flavor of our county. Please don't hold us accountable for zoning violations that may be occurring elsewhere in the county. The impact of this proposed use will be negligible. We ask that the board give us what the rules say we can have with conditions that are fair and reasonable. Thank you.
Does the board have any questions of the applicant?
I think it's pretty good. A good presentation.
Okay, and I'll open up the public comment period for the public hearing. Anybody wishing to speak, you have 10 minutes. Each person will have 10 minutes based on the time the applicant has took. Are there any public comments? Please.
Deborah Nick, Hampton District. I live and share an adjacent or share a driveway with this special use permit applicant. And I am concerned about the noise. I am concerned about the hours of operation. I am concerned about the unknown traffic on a very rural road. You know, we try to be good neighbors, and it's pretty disheartening when you think that all you're going to hear is noise when you get home from work every day. I understand agriculture. You know, my family's been in that for generations. I understand logging, but we've never hauled logs into a property. The road, I know that Boarddocs said that they didn't have an issue. They didn't, to my knowledge, come and actually look at logging trucks going out. I am concerned about the stream crossing and the disturbance of the stream. That's something that occurs rather frequently. And there are native trout in the stream. And I think that the Planning Commission, the conditions that they set forth were appropriate and looked out for the neighbors. That's all I have.
Based on the current usage that they do right now with logs on the site, do you hear much noise now?
I have not seen one log go out since this special use permit came about. I was told that it was going to be a hobby, and that was from a supervisor, and now it's a full-blown commercial activity. I haven't seen any timbering go out at all, but now I'm not there 24/7.
And you have heard no noise?
I have heard no sawmill noise, no.
And you are operating now, correct? Just with lumber from your property?
We are running the sawmill on very infrequent occasions because of the situation.
But you can lumber,
We have
Take
it by
lumber.
right, yeah,
By
from the
right?
tree farm.
Yeah. So by the way I read your application is that that's what you're primarily doing now, is leveraging logs from your tree farms, which would make sense. So you have all 160 acres. So you have a lot of trees to log, and you wanted the ability to bring in more valuable logs, but it sounds like, I don't know, so there's a disconnect there, I'm not.
Yeah. There's a disconnect between your proposed request and what you seem to be asking for now, because in your proposed request, it says it's anticipated that the retail customers will rarely visit the property. The estimated average additional trips generated by the proposed special use permit will not exceed 1 or 2 daily trips beyond those already generated by right.
Right usage, exactly.
So I don't see how 4 trips, 2 round trips per day is overly restricted.
Is what?
No, it's not.
Oh, I thought you were objecting to it.
Well, she was asking that we consider the code here that said 10 trips, allowing 10 trips. Where was that?
Okay, let me ask a question in that what the past history has been is you have been logging the property, which is basically cutting the trees and cutting them into length, putting them on truck, and they are taken to a mill where they are milled, is that correct? you don't mill, you don't do fence boards or anything like that on the property right now. You just cut trees and they go to be milled elsewhere.
We have, in the period of time that we've owned the property, we have logged perhaps 4 times. And we have actually not done it ourselves. We have contracted it.
That's my question is, the extent of the operation, and that there's a difference between cutting the trees and milling lumber. Milling lumber is you take the tree and you turn it into lumber, and around here, or whatever, it's, a lot of times it's just fence boards or whatever, it depends on the tree.
Right.
And you have not been doing that, but that is what you're proposing to do, is that correct? You're not having people bring in logs to your property to cut them into log sections and then take them back out. You're going to take those logs and mill them into a product, some type of boards.
We
Your
have,
own logs, so
No, from, well, both, both, as I said. So in the past, they have been cutting the trees and sending the trees to a mill. And what they're proposing to do now is cut the trees, mill the trees, and also allow other people to bring in logs to be milled. And then they will be if they're, say, fence boards or whatever, and it's a custom operation, I guess the person takes the boards, they take them to the farm, and they build the fence. Is that correct?
at the moment, what we are doing is creating lumber or timber for our own structures. We have 2 houses, and anything that needs repair, we are doing that ourselves. And that's the extent of what we've done so far.
Okay.
But what you're proposing is to run this mill 10 hours a day, 5 days a week?
That is, that is the rules as per the zoning regulations. And we're asking that it simply is what is extended to us.
What is
Well, I
your,
don't see that in the
what is your source of power on the property?
It's gas. The sawmill is gas run.
Gas meaning, gasoline engines?
Yeah.
Gasoline engines, okay.
All right.
Does anybody else have any questions or comments?
Is this the farthest, is the site where you have it as far away from the next property as possible or convenient? I mean, could you move it to a place that was a little more remote without trouble?
Well, it's technically a portable sawmill.
Right.
So I guess we could potentially find another site on the property. But what I am envisioning as the other site would be difficult. Where it is currently is an old clearing where logging occurred before.
I have a question for Ms. Nick. What time do you get off work?
4:30.
So, I mean, if they suspended their work hours at kind of the normal 5 o'clock, you would probably not be impacted by it, because you're taking almost that long to get home, right?
Depends on what your definition of impacted is. I mean, if I'm meeting a log truck on the way down the road, or, coming out the driveway, yeah, possibly. I could be impacted no matter what time I got home.
Oh, you mean you're afraid of meeting trucks on the driveway?
Any kind of vehicles.
Well, I mean, it's a driveway.
I think my point is there's more issues than just what time I get off work.
All right, so I was just wondering, they're trying to limit their hours to 4 o'clock, and that's kind of like, imposing upon the natural flow of business to ask people to just close their business before 5. I mean, 5 is kind of a reasonable time. Most, thereabouts.
Someone else, Commissioner?
Anita Rivers, Hampton District, just to keep mixing in with the idea about hours. You say, they've said 10 to 4, you're thinking 10 to 5, whatever, but also please consider holidays. This is when the neighborhood is all at home. And so asking them or telling them that they shouldn't run their business on a federal holiday would be a little bit of help along the way. Okay.
Are there any more public comments? If not, I will declare the public comment period closed. So now we need to, does anybody else have any comments before Joe? As far as basically thoughts on the proposal.
I think what's presented, it's very hard for us to determine the impacts not only to the environment but also the neighbors, considering the way I read this before, it seemed as if they were already doing this just with their own logs. And that this application was to bring in new logs to an existing process or operation. And it doesn't sound like that's the case. It sounds like this is, going from what they can do by right plus some altogether, based on its proximity to the park, based on the Ford. I think these are all very, I find them very concerning, and I would have trouble supporting this application, and even with restrictions.
How about requiring the Ford be maintained
I think they can do a lot by right. They have 166 acres.
Right, oh yeah. I mean, what they're asking to do, I did for years on my property right down the road. I brought in logs that were 40 inches in diameter and sawed them up and made a barn for myself. And I made, I don't know if I didn't realize I was doing something that was untoward, but I was, selling it to my friends for their barns. I can't, I have neighbors, nobody, they're much closer than a quarter of a mile, and I never had a complaint. And I ran every night, even holidays, weekends, Sundays, and they're not that, these machines are not that loud. I mean, I worked for years, often 8 hours a day with no hearing and, no earphone, no muffs or anything, and I never had a problem.
Well, that's why I say if there was a precedent of them doing milling trees on their property now, I think we would have some kind of threshold to know, the impact, but we don't.
What would potentially be, you can't deny them because you don't know something. You have to basically deny them on some.
I think it's an
actual
appropriate
thing.
use for the specific location, about the access to the property itself, going through a stream.
Have you been up there?
I did.
Well, I go up and down that road a lot, and having a lot of logging trucks coming out there just does not seem very safe to me, but I would defer to the staff recommendations. I think the recommendation about complying with the Virginia Code and the regulation of the Department of Forestry, no structure, no storage of lumber, logs, chips, or timber, hours of operation from 10 to 4. I think that those are all reasonable requirements. No subleasing, no commercial signage, no retail sales. I think that all was reasonable.
Right, 8 to 4 would allow people to work a full week. And somehow I don't think that this is gonna be, are you planning on doing this like 5 days a week on a regular basis, or is this just an occasional operation?
We would like what is offered in the code such that we could, but my feeling is that it will be far less.
Right. If you have 1 mil,
1 mil.
But how do you, I just don't get how you jive the 5 days a week, even 10 to 4 with the, you know, that they're gonna be, you know, it's not anticipated that you're gonna have a lot of people coming in.
I don't believe there will be a lot of people coming in. But again, we are asking simply for what is reasonable under the zoning regulations as you can apply for this permit.
Okay, but, you know, we're responding by what we can do, which is we can limit your hours of operation, and we can determine whether or not it's gonna fit into the neighborhood. We can, you know, we can place time limits, we can place all kinds of limitations under our authority, so. And the suggested limits seem to me entirely reasonable.
And you mean the recommendations by the planning commission, not the staff,
The
correct?
staff,
The staff recommended, shall occur between, no sign, shall be conducted between 7 PM and 7 AM.
well, the one I have is,
You might be the planning commissioner.
no, staff recommendations can be cool.
Staff, I've got the staff report, what am I missing?
Do you have the May 19?
Maybe there's dorms.
Here, this is what I'm looking at, trade. Oh, yeah, this is different. Oh, yeah, you're looking at the planning commission. Oh, wait, no, this is
That's
staff.
different. Which one, maybe we could get some clarification.
You could ask the staff.
Staff recommendations,
Michelle, I'm pulling out, what I was reading from was what was in the folder.
Correct, my recommendation to the planning commission is changed in your own because of what their recommendation was.
Oh, so you changed based on the planning commission? I see. That was your original recommendation?
Yep.
I see.
Okay, what you have to think about is, number one,
That's a,
the totality of the request. In that, if you are granting a 5-day-a-week, 7 to 7 permit, even though the applicant says, I probably will never get to that point, whatever, they still have the option to get to that point. And this area is yes, it's agricultural, but it's sort of agricultural residential. And that there are a lot of folks that live up the hollow there that aren't involved in farming, and they have bought property because they want to be back away from commercial operations or whatever, and want to enjoy the peace and quiet. We don't know, what that sound is going to be, but we do know in the hollow the sound tends to amplify and channel down the hollow. Another similar operation, the operation on Meadow New Road, that with the woodlot there, and the big complaint of the folks that live there is the sound of the belt drive equipment that's operating on a daily basis, and it just drones on and on all day long and keep the belt running to stack, run the wood up on top of the piles. I would see the same thing here, that you said that power is generated by gasoline. That means you got a generator running.
No.
No, there's no generator.
It's just a sawmill.
No, it's
Just gets in
It's
there, turns the thing and.
well, okay, it's there is a gasoline engine that is creating the drive mechanism.
Right, it's just like a
It's
car,
not
it's not that turns the saw blade.
But and then there's the sound of the cutting. Of the actual sawing, which also, and like I said, we don't know what that is. And in defense of what has been said about, people's working hours or whatever, people don't work forever, they retire. And this permit would be open-ended. It's not for a specific period of time.
The planning commission, I think, put a 2-year.
Yeah, I think that's totally.
Oh, okay, yes, if we went with the 2-year,
I think that's what that is totally reasonable.
but the applicant was opposed to that, with that.
Well, I think that's, 2 years is unreasonable, like the point was made that if it's not working out, they can always be rescinded, but there's no reason to rescind it before there's a problem.
Well, another issue that I think the applicant brought up herself was that, if there is an issue, it's hard to really discern what is by right and what is by permit. If there's noise issues or vehicular issues or environmental issues, how do you determine if the neighbors are raising an exception? Oh, well, this is with respect to the by right, or no, this is with respect to the special use permit. I think it's impossible to kind of draw the line.
This is a commercial operation.
It is.
And it's not commercial over there, and there's a reason for that.
No, let's get our glossary out. This is technically, a commercial sawmill is not what this is very specifically by rule. This is a custom sawmill. This is 5 people or less. Commercial is 5 people or more. And this is not, and I object to calling it a commercial operation because it's by definition not.
By definition of our ordinance, yes.
Right, right, so let's kind of like.
But also,
Just like a tourist home would be a commercial operation. Just like a tourist home by a special use permit to operate it is really a commercial operation. It's the same.
Well, there's two different definitions here. Just because one is making money and commerce is occurring does not necessarily mean that it is a commercial by definition by the code operation. It is a custom operation which is obviously going to make money from custom sawing, but it's not the same thing.
okay. So, do you have anything else, other points that you can make? Is the board ready to,
Well, I think some of these things are unreasonable. I think you probably ought to just, does the board think it's reasonable to, so limit them to let, I'd like to see them permit, if they're gonna shut down at 4 before, people come home from work, I think that we could allow them to start at 7 because that's permitted. And somehow I don't think this is going to be going on 5 days a week, 40 hours a week. That's just not going to be happening. I used to run a sawmill, I know that. Yeah. The maximum is not likely. However, they would like to have that possibility if they had a job and they wanted to work all week. I think they should be allowed to put in a good week's work. But somehow I don't think this is a custom operation. I don't think this is going to be,
every day, all 5 days a week. They're not geared for that, and that's not what they're doing.
But that's what they're asking for.
Well, if they want to be, I think they want to be able to do that when it's appropriate, but they're not deciding, I don't think, you're not asking to do that to run an operation all day, every day. You just want to be able to do it when you want to do it. But, I mean, you think you could even keep up an operation of 30-hour a week after week there?
I would leave that to my sons.
Huh?
I would leave that to my sons. And I think that they would probably limit it in and of themselves.
All right, well, then, yeah, well, that's,
And once again, I'll say that's, you can't interject that into the permit. The permit says 5 days a week. So, and so they have every right to be operating 5 days a week, whether they're going to or not, and to consider yea or nay based on the fact that, well, they said they weren't going to, they're only going to do it 2 days a week.
I'm just trying to gather data points here. I'm not trying to make a motion based upon that. I'm just
Right, but
gathering information.
The point I'm making is that you have to consider what the request is for.
Right.
And yes, we can temper that request if somebody wishes to do that in form of, in starting to
Yeah.
formulate a motion.
I would make, and that motion is that we include the following conditions: all timbering and milling operations, including reforestation, the restoration and disposable timber, stumps, sawdust, and other debris, shall be conducted in accordance with Title 10.1 of the Virginia Code and the regulation of the Virginia Department of Forestry. 2, no structure or no storage of lumber, logs, chips, or timber shall be located closer than 100 feet from any lot line. That the hours of operation shall be Monday through Friday. There shall be no subleasing of this property, no commercial signage, no retail sales from the property. That there be 4 trips, 2 round trips per day, 2 axle trucks shall be used for logs in or out, and that the permit be reviewed in 2 years from the date of issuance.
Can the board make those findings? And the general standards, section 170-52?
Ask for a second.
Well, fair enough, is there?
Yeah. Is there a second? First, okay, in order to have findings, we need to have a second. Is there a second to the motion?
No motion.
Is there a second to the motion? Okay, the motion fails for lack of a second.
Okay. If, I would second it, if it could be amended to some degree. I don't think, expiring a permit in 2 years is a reasonable request. We have to
My motion
restrict
was
that.
that if you reviewed it in 2 years.
Oh, reviewed in 2 years is fine. If her motion says reviewed, well, I'm okay with that, but I don't think we should expire somebody arbitrarily, that's arbitrary.
Reviews are problematic. There is nothing to really in our code or in our rules to trigger a review. It really has to have an expiration or it's indefinite. It's really one or the other.
Well, I mean, it's not indefinite if they do something that contravenes what,
But there's
practices and somebody comes in. Is there a way that if they did something contrary to what we could require anything, but if they can just do something contrary to that, we can't, there's no recourse for us to proceed against them, what's the point of any of it?
Well, I think you get that no matter what. There's always the ability to come in and review a permit based on them not going along with the conditions that were specified. But I'm just saying the word review, there's no notion of that within our rules and procedures. There's no mechanism to enforce us triggering that within a given timeframe. It's either indefinite or not.
I don't think that's necessary, I just think well, my question remains. If we make the conditions on this and they contravene our conditions, what is our recourse?
Yeah, we did, and then they applied.
Well, someone will complain, and
Right,
then it will come back to the BZA.
and we would review it. So this is what we're talking about, I think.
So, but I'm saying by virtue of that, it's in a special use permit, it's not a specified review as a condition.
Right, no, but it would,
Inherent.
it would be automatic if someone made a complaint.
Correct.
So I mean, it's almost moot point to even mention it.
Was that a motion?
No, I'm just saying it's moot to mention it if there's nothing.
Okay, so the motion failed, I think.
Right, so can we formally make a motion that would,
Failed, it's on the floor, it's like you said.
yeah, right, so can we make a motion that would garner a sentence?
I'll just say, I can't get past general standard A. The proposed use shall be such that it will not adversely affect the use or development of neighboring properties and shall be in accordance with the zoning district regulations. I also have issues in making findings with respect to the scenic qualities of the immediate area. And then the section F, which is respect to air quality and surface and groundwater.
Yeah, I have a problem with that too, the groundwater thing being forward. You know, I would like to see that adjusted somewhere, because that, you know, I went downstream from that.
I can't make 3 of the findings just off the cuff, so I'm not likely to second any motion that involves approval.
And agree with all you're saying.
Well, I guess I'll make a motion to deny the permit based on the inability to make findings in 170-52A, finding F, and finding I.
That's it?
Do you have a second? Did you make, that's a motion?
That's my motion.
Do you have a second?
I'll second the motion.
Any discussion? I'm taking the meeting over, I'm sorry.
Okay.
Okay, well, my discussion is that I think that there is a way of running a sawmill, that's a portable sawmill, that is in accordance with the applicable zoning district regulations.
I think so too.
So,
And I don't think it's really right down, this is certainly.
They use the trees on their property.
Huh?
And if it's a portable sawmill, so take the sawmill to where you're getting the logs.
Well,
I mean, that's the way I look at it.
right. It's not a permanent, something you need to go in. We're gonna permit to have.
And if they were operating it with laws on their own property and there was some kind of understanding of the condition of the neighbors, I think we have something different to work with. But you've heard the neighbors say that they're not operating it really right now. At all.
Well, right, they're not operating. Right, but I mean, obviously they have a by right operation.
Absolutely.
Right, they can do whatever they want as long as this is on that property. And they don't need a permit for that.
Exactly. Like, they can do almost everything they
So
want.
are we saying that the application is moot because they can pretty much do what they want anyway?
no.
No.
Is there something here that
They are asking for the custom feature because they want to bring in logs that do not come from the property. That's why they're asking for the permit.
Well, I mean, she said they're using this for their own buildings. It's not, they're not,
They
they
are
want the
not,
opportunity to sell it, but
they are requesting to be able to bring in logs from other locations,
right.
and then the lumber will be milled and then it will be taken back to that location that it came from. It's not going to remain on the property.
Is that true?
It could possibly remain on the property.
But
Could very well.
I thought
Possibly
all my
it's not
buildings
what
were
we're
logs are right onto
issuing
the
a
property.
permit for.
We don't have logs around here that we do.
we don't have logs around here that are appropriate for all kinds of building. I bought probably 10 truckloads of 40 footers full of timber that was like, 3 feet in diameter. And
Wait, that's not a commercial use. If you buy a log commercially and you bring it on, you mill it, and you use it on your property, I don't see that as a commercial use. Under the scope of this
I
application.
mean, it's not a commercial use.
Okay, I think we're debating an issue that has.
Yeah, okay,
This is
I was
custom.
going with you guys.
The custom is a different thing.
We just got a third one.
We have a motion that's been seconded. We've had our discussion, it's time to vote. All in favor? Aye. Opposed? Motion passes. Permit is denied. Okay. We've had our discussion on the rules and procedures, so we'll do that at the next meeting, and therefore I'll entertain a motion to adjourn.
I move that we adjourn.
That's okay.
All in favor?
All right.
Aye.
We're adjourned.
Hey, you just got a.
I had to jump that.